Good morning. Good morning. Good morning. All right, I had to test that. I was having a lot of difficulty yesterday with the audio. So they just gave everyone a break, a potty break. It started about, I don't know, maybe 45 minutes, an hour ago, but I was at an appointment. I think he asked Letecia if she was okay. But then he said something like, you see what I have to deal with, or something like that to her. Sorry, my dog is faint. Probably about 5 more minutes. And they said they would go until 12. So what is Colorado? What time is it in Colorado right now? 10? So about 2 more hours. Oh, my dog is coughing so bad. We just found out that about a month ago that she has cancer. She's 15. So if you hear her coughing, that is why. I'll stay muted though. They should be back in about 5 minutes.
it all down. Yeah, that's the, oh, good. I'm glad you paid attention. I'm number 12.
Council, approach for just a moment.
See,
No.
memorizing again.
I just wanted you guys to be aware that it was coming. I'm just going to excuse probably about 23 or 24 right now. I just wanted you to be aware so I didn't get into the numbers and you missed a bunch of them. Right. Already saw it coming. So, yeah. Look at the. Yeah, he doesn't even need to come back. I apologize for the confusion. It's my fault. Because usually what I say before we take a break is that please remember where you are before you go, because we honor the third grade seating chart here. And I didn't do that, and that's my fault, and I'm sorry for that. So if it is causing some confusion as to where some people should be, I think we're still missing a juror. We are. Right, we're missing number 5. I'm sorry. Yeah, I told him not to worry about it. All right, I think we have almost everybody. we're missing one, but that juror was going to be excused in any event. So I have taken the time to look through, or I've used the time to look through the juror list, and I'm going to excuse the following jurors at this point in time. So if you're excused, you can go ahead and leave and go about your business. You don't need to go back to the jury assembly room or anything else like that. So I'm going to, you okay? It's just one of those days. It's all right. Sometimes it happens. It's okay. All right. We might be able to get you a new one.
Yeah, probably.
It's okay. It's a Tuesday. All right. So if I excuse you, you can go ahead and leave and go on about your business. You don't have to report back to the jury assembly room. And everybody else needs to remain in their seats. So I'm excusing juror number 4 in the mask. In the front, juror number 12. Juror number 20 on the end. Juror 20 on the end. That would be you. You're excused. Yep. And I just remembered what I learned from yesterday, and that is to excuse the people in the back first. So I'm going to change it up a little bit. I'm going to excuse juror number 71 in the back. 73. The gentleman next to you. 73. Yes, sir. 74. 68. And 67. Wait a minute. Yep. 68 and 67. Oh, 68. 67 is already gone. 67 was the gentleman with the heart condition.
Yeah.
Okay. And so now we're up to speed here. 62 on the end. Yes. 59. No, hold on. No, stop. Go back. You're right. Okay. Okay. So, let's see. I had 62. And 58. Thirty-five, 37, 39. I'll do it. And juror 30. And okay. So that worked a little bit better. Okay. Now let's start the next part. Okay, so what we're going to do now is I'm going to have the staff hand out some witness lists for you. These are people that we anticipate will be witnesses in this case. The question that I'm going to have for you is take a look at it and let me know at the end if you know anybody that is on that witness list. Is council up to speed on who I excused, or do you need to see my sheet? Prosecution? Are you guys okay? Mr. Tellini, are you okay? Okay. There are a lot of witnesses, so if you want to write some names down or something like that, there are those notepads there on the bars in front of you and some pens if you need to do that, if you have a question about it. I'm sorry, I didn't realize Todd left. I should have helped you. I'm sorry. Okay. Ran a little short.
Thank you. Oh, sorry.
Kathy, can you get that door for me, please? Thank you. Got two more. All right, has everybody is there anyone who has not had a chance to look at the witness list yet? If so, please raise your hand. All right, it looks like everybody has. Prosecution, is there anyone else that the prosecution intends to call as a witness in this case that is not on that list?
No, Your Honor, thanks.
Defense?
Yes, Dr. Rhonda Niederheiser and Caitlin Craig.
All right. Do any of you think you know, does any juror think they know any of the potential witnesses in this case? Please raise your hand. Okay, it looks like we have a couple. Let me start in the far back. Juror number 66, who do you think you know? Who? Okay, and how do you know Detective Stauch? Okay, okay. And I don't know, this is a potential list of witnesses. I don't know whether these witnesses are going to actually be called, and some of them may be important, some of them may not. Some of them may have, 2 minutes worth of testimony, and some may have 2 hours. I don't know. The question that I have for you is, could you judge Detective Stauch's testimony just as you would judge anyone else's testimony? Okay. All right. Nope, that's fair. There was another hand, there it is. Let's see. Hold on a minute. Juror 45, who do you know? No, wait a minute. This woman here, you had your hand up? Yes, ma'am. In what? Right. What kind of job did that Josh Johnson have? Does that sound like the same person? Probably not the same person. Okay. All right. And was there another hand back here? Okay. In the back, and juror 61. Yes, sir. Brandon, last name? Bullard. Okay. Since the name sounds familiar and you're going from that, it sounds like not close friends. Okay. Suppose that this is the same Brandon Bullard that you knew. And I've had it happen where people don't realize they know somebody until they take the witness stand. And I remember one trial where a juror gasped, and I'm going, how bad is this? She just said her name, and she was just going, oh, I remember. So we had to have a conversation with the juror, and she said, oh, I remember from school years and years and years ago. So the question is not whether you know them. The question is, can you judge that person's testimony just as you would judge anybody else's testimony? So the mere fact that even if this is the same Brandon Bullard that you may have known from high school, okay, so even if it's the same person that you may have known from high school, you can just look at their testimony just as you would anybody else's? Yeah, okay. All right. Is there anyone else? Oh, over here. Let's see. 2, 3, 4. Juror 15.
The F&E nurse,
The who?
the F&E nurse at UCL.
Amanda Ben.
Amanda.
Okay. And how do you know her?
Co-workers, I used to manage the HIM department for UC Health centrally.
Okay.
And I've done medical records as well as the actual F&E medical records. I've looked through them. I've worked very closely with that department.
Okay. And again, I don't know how she fits in or what it is that she did. But would you be able to judge her testimony just as you would be able to judge anybody else's testimony?
I might give more credence based on the knowledge I have with medical records and stuff like that. So I might think that that would bear more validity.
Well, that's a little different question, because what I'm asking here is not so much the records or the work that she did, but her as a person. So suppose she comes in and she testifies about something that has absolutely nothing to do with the records or anything like that. Would you be able to judge her testimony just as you would judge anyone else's testimony?
I'm not sure, to be honest.
Okay. So do I have it right that what you're really looking at is you have some experience with the type of work that she does, and because of your familiarity with that work and having done some of that work at that facility, if she were to testify about that, you would give it more credibility.
Probably.
Okay. It's all taken care of, whatever. So he's just gone. Don't worry about it. Okay. At this point in time, I'm going to have the attorneys give you a 2-minute mini opening statement. It's just an opportunity for them to tell you what they think the issues in the case are. It's not necessarily what you'll find them to be if you're selected to serve as jurors in this case, but it does give us a starting point for a conversation. With that, prosecution.
Morning. January 27th, 2020. Letecia Stauch, 11-year-old boy, was taken, brutally murdered. The evidence in this case will show that the person who murdered Letecia Stauch is the defendant seated over here to my right. And when you look at the evidence in this case, you have to evaluate it as to what's going through her mind at the time that she's killing Gannon. And the way you do that is look at her actions and what her actions were. What her actions were, stabbed him times. Gannon was fighting for his life. He had his arms up. He's got cuts on his hands, cuts on his arms. He's got 3 stab wounds to the chest. Got a stab wound to his head. Actions. He also took a blunt force object and crushed his skull. Fractured his skull. Actions. Then she took a gun. She had to get the gun. She fired that gun 3 times. One of them striking him in the chin, causing his death. But it's not only during the commission of the crime that the evidence is going to show that not only did she participate and do this crime, but she was legally sane at the time when she did it. Because she did actions afterwards. When she fired the gun, 3 shell casings come out. Those shell casings are never found because she took the time to pick them up. Not only did she take the time to pick up those shell casings, she took up time to clip the mess she made because he was killed in his own bedroom. And there was blood all over the wall. There was blood all over the mattress and blood on the floor. And she took the time and effort to clean that up so that she hopefully would not get caught.
Wrap up, please.
She also gave numerous versions of what happened to Gannon on January 27th, 2020. The first one was that he just went to a friend's house and ran away. She changed her story depending on what evidence was presented to her. At the conclusion of this case, you'll see that her actions led her to the charges, and we will be asking you to convict her of every charge that she's charged with, and we will be asking you to find her legally sane at the time that she killed Gannon Stauch. Thank you very much.
Thank you. Defense?
What? All the things Mr. Young just told you, we're going to hear. A horrific, violent event. A brutal homicide. We're going to hear that Ms. Stauch afterwards gave numerous versions, stories. Afterwards, each growing in, each becoming more irrational as she told. You'll also hear that the evidence circumstantially will clearly indicate that after this 11-year-old boy was killed, that he was stuffed in a suitcase, transported to Florida, discarded there, and left for over a month until his body was found. You're going to hear and see photos from the autopsy of that boy who had been brutally murdered, and that was in a state of decomposition. We'll also hear, though, from Dr. Dorothy Lewis, examined Ms. Stauch for over the course of 3 days and 14 hours, who's from Yale, who's had 4 years of experience dealing with this, that based upon her interviews and her review of the mental health history that Ms. Stauch has had, that she, among other things, suffered from dissociative identity disorder, formerly known as multiple personality disorder, that when this event took place, she was in a psychotic state and detached from reality, and in the opinion of Dr. Lewis, was insane. Thank you.
All right, thank you. You've heard the attorneys tell you a little bit about what they believe the facts in this case are and what the evidence will show. Please understand that nothing that the attorneys say at any point in time is evidence. What is evidence is when a witness comes in, raises their hand, swears to tell the truth, takes that seat and tells you what they have to say. And then there are rules of law and evidence that apply to their testimony as well. The attorneys never take that oath. They are paid advocates in hoping to convince the jury of a particular position. So nothing they say is evidence and is entitled to any evidentiary weight. In this case, you will be asked to render a decision based on the evidence presented in this courtroom and the instructions that I give you. Even if you have heard or read something in the media, the real question is whether you can put that aside and decide this case based on the evidence you hear in the courtroom. Is there anyone here who thinks that they may have heard something about this case? I'll just say in a wide variety to include Facebook, and I have no idea what's out there. But does anyone think that they've heard anything about this case in any form or fashion, from friends, from television, radio, print media, anything like that, and thinks they cannot set that aside and decide this case based only on the evidence presented in this courtroom? Please raise your hand. Okay. Again, we're going to start in sections. So juror number 1, yes, ma'am.
It would be very difficult for me to be impartial. I just, my evaluation's the first one.
Okay. And there were other hands up here. Let me go in the back. That would be juror number 7.
I too have heard a lot on TV, seen a lot, and talked a lot about this, and I really don't think I can partial on this because I don't agree with the insanity. I really think it would be hard for them to change.
Okay. And you understand that, I mean, people are talking all kinds of what conclusions should be drawn from sanity evaluations, but there's not any evidence of that or why they concluded. You would actually hear the experts in this case make a determination regarding whether they, easy for me to say, why they did or didn't believe that she was sane at the time. Do you understand that? Okay. But you feel like your mind is made up pretty much? Okay. Front row and let's see. 2, 3, 6. So, juror 16?
I work at a grocery store and talk to a lot of the customers and other employees, and we've had quite a bit of conversation as everything's going on with that. And my mind is basically made up as well. And I have an 11-year-old son as well.
Juror 17?
Yeah, I'd like to believe that I could be impartial, but with an 11-year-old child. And from what I've heard, and I just accepting an insanity plea, it seems awful.
Okay. So for you, it's not the publicity issue, it's the 11-year-old issue.
It's that, and I mean, I remember reading about it. I didn't go into detail with it.
Right.
I remember having a very visceral, emotional reaction to the situation.
No, and I appreciate that response because we do a lot of different kinds of trials, and unfortunately, some of them involve young victims. We have this case does not involve it, but and that's kind of why I'm choosing the crime, even though it sounds and it is terrible, a sex assault on a child. We deal with those oftentimes. And I often hear from jurors say that they would have difficulty dealing with that kind of crime because it involves a child. And the question is whether or not you think that you can put that aside and just decide the case based on the facts. Do you think that you can do that?
Don't know.
Okay. All right. And was there another? I'll get to you in a minute. Was there another hand in the front? No. And juror number 6. Yes, ma'am.
Hard time with the insanity. Talk with my family and friends about.
What is it about? You said that you have difficulty with the insanity plea. What is it about that you have difficulty with?
I just don't believe that she's a.
Okay, and it could be if you haven't heard any evidence about this case yet, right? Okay, so it sounds as though are you? I'm just trying to understand what that is based on if you don't have any evidence on it.
Yes.
Okay. And before I get too much further, I'm going to ask questions about insanity separately. What I'm trying to find out at this point in time is the issue with respect to publicity and whether or not there's anyone who believes that they would have difficulty setting aside publicity that they may have heard in this case and deciding the case based on the evidence. Is there anyone who feels that way? All right. Juror 8.
Yep. We were looking at house sessions in January of 2020, and we actually drove by, I think, where a lot of this was going on, and that, you know, we were curious about what was happening, and we looked into it a little bit. It's shocking here at that time, and as it's grown, we.
Okay. Would you be able to set aside the publicity aspect and decide this case based on the evidence?
I'm not sure.
Okay. And is there a certain certain things that you remember from the publicity that are causing you an issue, or?
I mean, I feel relatively biased on, what child deserves, what no one deserves, you know.
Okay. And I'm fairly certain, and I've presided over a lot of trials. And I think Mr. Tellini has painted at least some of what I anticipate the defense will be. And I don't think you're going to hear anybody in this courtroom say that this was deserved. I don't think, frankly, you would hear anybody in any courtroom say that this was deserved. The real question here is whether or not it meets the standards set forth for conviction, or has the prosecution proven beyond a reasonable doubt everything that they're required to prove beyond a reasonable doubt. So, and I'll get into that in just a minute. Again, at this point, I know it's hard for people who are not trained in the law, but at this point, I'm only asking a very specific, very discrete question. And that is, forget everything else, just with respect to publicity. Is there anything about the publicity that you think you could not set aside?
I'm not sure.
Okay. No, that's fair. Okay. All right. And back here, this section in the front row, any hands? No. Juror 55? Yes, sir.
My opinion on this is that I believe it's evading, talking about taking responsibility for it.
Oh.
Basically copying out and trying to shift the blame to something else other than the person.
Okay, let me stop you for just a moment, because those are all valid opinions and opinions that I need to know about. But my question is very narrow, very narrow. The only question that I'm asking at this time is whether or not there is any publicity that you have seen, heard, or experienced that you think you could not set aside. We're not talking about insanity. We're not talking about an 11-year-old. We're talking about just the publicity. I will get to those issues. I promise I will. But because of the way the law works, there's certain discrete ways that I have to go about doing it. So, and by discrete, I mean I need to know specifically what the legal basis is for something. So I'm just trying to find out if there's publicity that you've been exposed to that you think you cannot set aside.
It's the going to another state with child diversity case. That's
Okay. All right. On this side, in the front, Juror 31, you have the most, that would be you, the one with the unique purse.
Yeah, there has been lots of. Nothing why it's another area.
That's where you grew up? Okay.
This is right around the corner from where this happened. I didn't participate in part of it, but all the publicity that has been going on, my mind is kind of been made up. And I'm positive I can't overcome.
Okay. Anyone else in this front row? Okay, second row, Juror 43, striped shirt. That's you. Yes.
I don't think I did. All kinds of things.
Okay. Juror 44. No, the girl in the gray sweatshirt. Did you? Oh, I thought you did. I'm sorry. Okay. Juror 45. No, that's all I need. Let's see. Oops. And let's see, that would be juror, I think you're in the wrong place. Yes. Okay, because I have, yeah, that's what I have, but I have him as being excused.
No, I still have them.
Okay, all right, then I must have marked it off wrong. Okay. Juror 47, go ahead. Yes, sir.
I experienced personally.
Okay. That's what I was confused a little bit when you said the construction site, not on this house, but there was construction out in the area. And so you drove by in that area every day. Okay, I got it. That's what I was a little confused there for a minute. Okay. Okay, next row back. You're 57? Yes, ma'am.
I don't think that I can change the case. The foster children, I adopted the last 3. Don't, that I can be truly get what she may need. Wrong of me to do that. But my heart is already tearing for this child. I had a cousin that was stabbed 27 times. And then had her body part of my family. I just don't think that this is where I need.
Okay. All right. Anyone else in that row? Row behind. And last row, juror number 70.
So, social media aspect, I'm on all time. I'm on all. But and I made what I.
Okay. Anyone else in that background? All right. All right. Now I want to talk a little bit about the process and the law that applies to this case before I move into a different area. Every person charged with the crime is presumed innocent. This presumption of innocence remains with the defendant throughout the trial and should be given effect by you unless, after considering all the evidence, you are then convinced that the defendant is guilty beyond a reasonable doubt. The burden of proof is upon the prosecution to prove to the satisfaction of the jury beyond a reasonable doubt the existence of all the elements necessary to constitute the crime charged. Reasonable doubt means a doubt based upon reason and common sense, which arises from a fair and rational consideration of all of the evidence or lack of evidence in the case. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. If you find from the evidence that each and every element has been proven beyond a reasonable doubt, you will find the defendant guilty. If you find from the evidence that the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you will find the defendant not guilty. You may have to decide what testimony to believe. You should carefully consider all the testimony given and the circumstances under which each witness has testified. Consider each witness's knowledge, motive, state of mind, demeanor, and manner while testifying on the witness stand. And, depending on how you view the testimony, you may believe all of the testimony of a witness or part of it or none of it. A few minutes ago, you heard me tell you that the defendant was presumed to be innocent. This means that if I were to give you a verdict form right now and ask you to fill it out, the law would require that you find the defendant not guilty. That's because you've not heard any evidence in this case and the defendant is presumed innocent. That won't change or hasn't changed simply because the attorneys have told you what they believe the evidence in the case will show. Now, someone may ask you whether or not you think the defendant has done something wrong or else you wouldn't be here. However, that's an improper question. We don't just randomly select people from the street to suddenly appear in a courtroom as a defendant in a case. Obviously, there is a process in place which resulted in the filing of charges against the defendant. However, the charges against the defendant are not evidence either. The charges against the defendant are just accusations. The fact that the defendant has been accused is not evidence that the defendant committed any crime. As such, the defendant is presumed to be innocent, and until the district attorney presents sufficient evidence to overcome that presumption beyond a reasonable doubt, you must continue to presume the defendant is innocent. Stated differently, unless and until the prosecution presents sufficient evidence to overcome the presumption of innocence beyond a reasonable doubt, Ms. Stauch's guilt has not been proven. That's what the presumption of innocence means. You may find it helpful to think of the charges in this case as similar to a recipe from a cookbook. When we get to the end, there'll be charges, and each one of those charges has certain elements. And the prosecution must prove each one of those elements beyond a reasonable doubt. Now, for instance, suppose for a moment that you wanted to have a Denver omelet, and you took some eggs and you scrambled them up. You added some ham, you added some mushrooms, you added some cheese. In that event, you might have a really nice ham and cheese omelet, but you wouldn't have a Denver omelet. If the prosecution charges the defendant with a Denver omelet, the prosecution has to prove a Denver omelet. No substitutions on the menu are allowed. Proving ham and cheese omelet isn't enough. They have to prove beyond a reasonable doubt what they have charged and not something else. I also want to talk about the defendant's right to remain silent for a moment. Someone may ask you whether or not you think you would need to hear from both sides in order to be fair. Everyone wants to be fair, right? And you can only do that if you hear both sides, right? But that's an improper question, because that's not the process that we follow in a court of law. This isn't the Maury Povich or Jerry Springer show. The government brought these charges against an individual. Because of that, the government has the burden of proving the charges beyond a reasonable doubt. The defendant has no obligation to disprove the government's case. The defendant does not have to present any evidence or any testimony. In addition, every defendant has a constitutional right not to testify. The decision not to testify cannot be used as an inference of guilt and cannot prejudice the defendant. That's because it isn't evidence. It does not prove anything and must not be considered for any purpose. Sometimes you will hear attorneys ask jurors questions that are intended to elicit a response from you, such as, Well, I know if I were accused of something, I would make sure that I took the stand and told my side of the story. That's probably a pretty natural response from everybody. I get that a lot from jurors. But as I indicated earlier, that's kind of a trick question because that's not the process we follow in a court proceeding. In any event, does anyone know what the number one psychological fear in the population is? It's higher than a fear of dying, and most people find it even scarier than meeting up with a rattlesnake. Yep, public speaking. So, of course, what we do is we bring you all down here and have you speak in front of everybody else, and sometimes get asked about some very private matters in your life in front of a bunch of complete strangers. All of you have been subjected to questioning by myself. Soon you'll be subjected to questioning by the attorneys, and I want you to think on that experience. Were you nervous? Were you uncomfortable? If you had a choice, would you choose not to be questioned? The bottom line is that it is possible that the defendant won't testify, and it's possible that the defendant will testify. But regardless of who testifies and who doesn't, the question is always the same. And that is, based on the evidence that has been presented, whatever that evidence is, has the prosecution proven beyond a reasonable doubt that the defendant is guilty of the crime charged? Is there anyone who thinks that they would have to hear from the defendant before deciding the issues in this case? Please raise your hand. No response. Is there anyone who thinks that they cannot give the defendant the presumption of innocence to which she is entitled in this case? Please raise your hand. Okay. Juror number 5. Tell me about that.
I think all murders should be death penalty cases. I think the insanity defense should not exist.
Okay.
I could go on.
No, I understand your feeling, and I mean, do you need some water back there? Are you doing okay?
Kicking my butt.
Okay. All right. If there's anything that we can do, throat lozenges, anything like that? No, it's okay. I just want to see if there's anything that we can do to help you. Okay. All right. No, I understand that. And I understand your feelings. And juror number 6, you had your hand raised. Tell me about that.
I just made up my mind.
Okay. Anyone else in the back row? Juror number 7?
Made up my mind too, and I just don't think I'll be able to change it.
Okay. Juror number 8?
I feel like I've made my mind. Believe in insanity.
Okay. Juror, I'm glad you did that because I almost missed it. Juror number 10? Okay. And in the front row? Oh, no, I already got that. Actually, juror number 1. Okay. Yes. Tell me about that. Juror number 1? Okay. In the front row? Juror number 13?
I don't know how I got lucky enough to be 13, but my problem is, I mean, if you kill somebody, you kill somebody. Whether you're insane while you do it, you still killed them. The insanity thing is,
Okay. Let me see if this helps. Okay. Because it's a really complex area of the law. And somebody else had mentioned the death penalty, and Colorado does not have the death penalty anymore. It did for a while, and I actually presided over a death penalty case. And even when the law recognized the death penalty, you could have a first-degree murder, but constitutionally, not every first-degree murder was eligible for the death penalty. At the time that Colorado had a death penalty, there were 17 aggravators that could be considered to determine whether or not the death penalty should be imposed. One of which was killing a number of people in a number of different episodes. Another one was doing it in a reckless fashion. So that's why it was applied in the Aurora Theater shooting. So because you had a number of murders there, you also had it done in a reckless manner. It wasn't targeted in any specific person. So that's what that was about. One of the issues about murder and sanity, if you are selected to serve as a juror, you will receive an instruction that is worded by lawyers. I just don't know how else to say it. And it says every physical act must be accompanied by a culpable mental state. And that's actually the language that it uses. And the reason for that is people can do things and certain actions happen, but you're not always held responsible for that unless some other mental state was going on. Oftentimes, the easiest thing to deal with are tickets because that just requires a certain act. You're going 65 in a 50. We don't care whether you meant to do it. We don't care whether you knew you were doing it. Those sorts of things. The sheer act of doing 65 in a 50 is enough. In other cases, criminal law is designed to modify behavior. And if you don't know that you're doing something, or you have a condition that is occurring such that you don't understand exactly what's going on, and I've had cases where insanity was pled before as well. I had one where a person beat their mother to death with a guitar. And I won't go into the long facts of that, but ultimately the law takes the position that it is not proper to hold somebody responsible for an act that maybe they didn't know that they were doing or that they didn't intend to do under the circumstances. Does that sort of make sense?
I guess yes, but
Okay. And then I'll get to the insanity part, which is a little bit different. Because the insanity part is that there was, and I have the instructions, and if you're selected to serve as a juror, you'll get those. But the insanity part is intended to have the jury closely examine the mental state of the person at the time the crime was committed. Because each act has to be accompanied by a culpable mental state. And the prosecution has the burden of proving both of those beyond a reasonable doubt. Does that make sense so far? Okay. So in an insanity plea, what the jury focuses on is the culpable mental state issue and whether or not there was that mental state that is associated with that crime. It could be, in Colorado, there's a number of different ones. There's intentional, there's knowingly, there's reckless, and that's pretty much it. So, but all of those have different, very specific definitions. And so the question is, was something going on such that they couldn't form a particular mental state? Does that make sense?
it does. The problem I have with it is at the time of the crime, this was this mental state. They're being evaluated after the fact. How do we know what that mental state is at the time that somebody's getting killed?
It's, and that part I get, and that part is for the experts. And you would also get an instruction if you're selected to serve as a juror, you'll get an instruction about what an expert is and those sorts of things. But ultimately, the last sentence of that instruction reads, you may believe all, part, or none of the testimony of an expert. So you can listen to what they have to say. You can say, this makes sense. In the Aurora Theater shooting, it did. In other cases, in the case that I had where the young man killed his mother, it did. And I actually was the one that made the decision in that case. That case was tried to me. So whether you believe something or not is an entirely different question. And I'm not asking that. And there's nobody that's going to ask you that, because that's improper. That's invading the juror's province. What you choose to believe is up to you. The question is whether or not, simply because it's an insanity defense, you're going to say, just not going to happen. Don't care what the law is. Not going to follow it. I just don't believe in it. And that's my question for you. Do you, or could you look at this and say, well, I don't know what the evidence is going to show. It might not. I don't know. Where are you on that scale?
I don't know.
Okay.
I mean, you don't know what you don't know, right? I haven't been
Right.
presented with evidence and.
No, and that's fair. And that's all I'm asking for is an honest answer. And sometimes the honest answer is, I don't know. And it sounds like maybe you have to wait until you get there. It sounds like, but at this point, you don't know. That's fair. All right. Anyone else in this? Okay. Juror 15?
Yeah, to be honest with you, I'm not really sure on if I'd be able to actually do that, and it's coming from a personal place. And having had some experiences as a child as well, and culturally, I think it would be really difficult for me to be unbiased
Okay.
in my responses, and how I would internalize that mentally.
You said something there, and I'm not trying to be insensitive, and I certainly don't want it to come across that way. But you said culturally, and I didn't, give me some context.
I was raised in the West Indies on one of the islands, and what happens is, and I can speak because I was raised there, and most of my family's from there. I do see that a lot of child abuse does happen, and it's natural. It's like normalized. Okay, so I
Okay.
mean,
Widely
personally,
accepted?
yeah, it's
Okay.
generally accepted
Okay.
to put you in your place, and that's the
Got it.
understanding.
Okay. All right.
Right? So like personally, I've been hit with pots in my head. I've been beat with brooms. I mean, I've been hit with hangers, and this is normal. Okay, so I would really have a difficult time processing that and really coming to a place where I would be unbiased. And that's just the honest truth.
Okay. No, thanks for giving me some context. I understand it a little bit better. Juror 16, did you have your hand up? Yes, sir.
Being a father of an 11-year-old boy, I don't think I can be unbiased in this situation.
Jurors, did you have, juror 17? Yes.
I have a question.
Yes.
So you talked to us about presuming innocence, right? But when I hear, if by reason of insanity, what I hear is really she's guilty. We have to decide whether or not her mental state excuses that.
You know, you have probably saved a lot of people 3 years of law school. Because to an extent that kind of is accurate. It is, go ahead. Yeah, come on.
When it is silent, it's them. It's has nothing to do with the sound. Thanks for joining, guys.
You sort of hit on an issue with respect to sanity, which is the mens rea. Here's what you need to keep in mind. The prosecution always, always, always has to prove everything beyond a reasonable doubt. Okay. So in this case, the instruction, it always starts out with, in the state of Colorado, on or about the date and place, and it actually has that kind of numbered out. And then it will say with intent, and then it will have some other descriptors. And they have to prove every single one of those things. And then at the very bottom, I think it's paragraph 6, or the very last paragraph will be, the prosecution also will have to prove essentially that she was sane at the time. They have to prove that she was sane. So with every case, the prosecution has to prove everything. There's no assumption necessarily that she did anything. As I said, if I give you a verdict form right now, you would have to find her not guilty because there's been no evidence that's been presented.
Well, I understand that in theory, but I can't accept that logically. That's what I'm struggling with.
What, help me understand the logic
But
issue.
I understand that, we haven't had any evidence presented to us. That 2 lawyers speak to us. They both agreed on the circumstances. Nobody said, no, she didn't do it. Just said that she was in a particular mental state.
Okay.
So that's kind of what I'm struggling with, because
Okay.
I don't know that it would matter what mental state she's in. I still think there's a punishment due.
Okay.
I'm struggling. I don't know that excuses anything.
Okay. Let me deal with both of those issues. Because they are separate. The defense, I'm sorry, let me back up. The prosecution will always have to prove everything. So they're going to have to prove that this crime occurred. They're going to have to prove that it occurred in a specific way. They'll have to show a manner of death. They'll have to show all of those kinds of things. They will have to show that it was this defendant and not somebody else that did it, or somebody unknown that did it. So they'll have to tie it to this defendant. Then the issue about punishment that you brought up. In the law, the position that is taken in the law is that if you have this mental state, so you either knew what you were doing or you intended to do what you did, and that caused you to act in a certain way, which resulted in the commission of a crime, then you should be punished for that. That makes sense, right? On the other hand, if you committed some acts, but you didn't intend for that to occur as defined by the law, or you didn't know that that was going to occur as defined by the law, and there's definitions of what intentional means and knowing means, so you'd have to figure out whether that applies or not, then the law takes the position that you shouldn't be punished for that because you didn't have control over the physical action that took place. As a result, you shouldn't be punished to the same extent as somebody who intended for that to occur and really set about a plan for that to occur. Does that sort of make sense?
It makes sense.
Okay.
I just don't know that I can put away
Okay.
I don't know that I can put aside how I feel right now, regardless of that. That's what I'm struggling.
No, and let me get to this very last part. That's where the insanity comes in, because if the jury were to determine that the defendant first of all committed this crime, and the defendant was insane at the time that the crime was committed, there would actually be a verdict finding to that that says that. Then what happens is the defendant is committed to, it's actually the custody of the Department of Public Health and Safety, and is committed to their custody and placed in a facility, a mental health facility, until such time as sanity can be restored. The idea being under the law that we do impose punishment on people who should and ought to be responsible for their actions. If somebody is determined not to be responsible for their actions because of a mental defect or mental health issue or something of that nature, then the idea is to get them the treatment or the help that they need so that they can be restored to a better mental functioning.
So what happens if she's deemed to be changed 10 years?
I don't have the answer to that. What I can tell you is that there are hearings that go through a person, if a person is found to be insane, they go through hearings because I've had those. So there are hearings that take place after that. There's a whole process for it, and it's long and it's complicated. So that's why I'm not explaining it. And does that help you understand it? May not change your mind, but it helps you understand a little bit more.
Yep.
Is that fair? Good. Okay. All right. Anyone else in the first row? First row over here. You're 23. Yes, sir. Okay.
To put any kind of belief in a psychologist or psychiatrist or whichever one it is.
Okay. And okay. And I want to make sure I understand what the issue is. Because who you choose to believe and what evidence you choose to believe, if you're selected to serve as a juror, that's your call. I'll just stand up, it'll be easier. That's your call. And
I understand that.
okay. So the issue, it sounds as though the issue is you're not sure that you would believe a psychologist or psychiatrist. Is that fair?
That's correct.
Okay. All right. Anyone else in that front row? Yeah, you're on deck. 41. Yes, sir. Yes, ma'am.
So I think similar to the gentleman in the dark jacket, I feel similarly. It seems awful convenient that this person is doing that they're well after this event occurred. To kind of topple on top of that, I don't have to be unbiased. My father just retired after 27 years in law enforcement. He's a police officer, a sergeant, a commander. And so growing up, when you have someone like that in your life, you can believe a lot of the things that they talk about and they believe. So kind of coupling all of this together from what other people have said as well. My mind's already made up. I have an opinion already, and I think going into this, it would be extremely hard, if not impossible, to sway what I've already kind of believed in my head.
Okay. All right. Juror 55, now we can talk about the issues that you had about the sanity and those sorts of issues. Did you have anything else that you wanted to tell me?
Oh, Your Honor, I go say once again, I just think it's trying to take responsibility.
Okay.
Access. Kind of cop out.
Okay. All right. Thank you. Anyone else in that row? No. All right. Over here, first row. Juror 31.
I want to go back to this juror hit on a good point. Should you keep an innocent until proven guilty? It sounds like from everybody's openings, guilty until proven innocent. Because nobody did, she didn't do this. Everybody seems to agree she did do this. What her state of mind was. And then I'm gonna go back here where he just said cop out with a word in my head. Cop out is me coming, I have a mental health background. I've worked in mental health before. And I was just a mental health tech for worked in mental health. And working with patients. I've had one patient tell me literally, like I could kill you up in here. He was like, I'd like to, I wouldn't do it. But if I'm a mental health patient, what's gonna happen? And So, yeah, I'm just not, I'm really not.
Anyone else in this front row? Next row, and juror 44. Yes, ma'am.
I work in childcare and I also have a background. I feel like for the
Um, uh, Juror 45. Okay. Okay. All right. Okay. Okay. I, I think I understand from everything that you've said. Okay. All right. Anyone else in that row? And the row behind, that would be juror 57.
I still go back to the thing of, I cannot change how I feel and what I think about this case.
Okay.
A child that somebody who is supposed to be taking care of them and stand in that. Have a very hard, I could not give her the what she needs. My mind has been made up. I hate to say that, but I cannot change something.
Okay. Row behind. Juror 65.
I'll just say I appreciate the way you're handling and explaining it. But the more you explain it to me, it may firm where I'm at. God's law. God's law has already been stated, basically. Colorado is giving her a way out of penalty. I do not think Colorado law supersedes God's law. That's at the root of an awful lot of discussion here. The question was, can I give her the presumption of innocence? And we're not, you haven't asked to get out people. But the question is so intertwined that I can't allow a presumption of innocence.
Right.
I'll keep it that, but I can go further, but I appreciate that.
I appreciate your honesty. Thank you, sir. Anyone else in that same row? One in the back, aside from number 70. No. All right. I'm going to ask the jurors to look around the courtroom. The question that I have for the jurors is, do any of the potential jurors know each other? No? Okay. Council, approach for a minute, please. All right, so ladies and gentlemen, what we're going to do is take about a 10-minute recess. So if I can have everyone back, and before we go this time, we do honor the third grade seating chart. So remember where you are, and remember to take that seat when you come back. But if I can have everyone back in the courtroom at, say, 11:45, and here's what you can expect. You already saw me excuse a number of people this morning already. My plan is to excuse some more before lunch. That's why we're taking the break now, so that I don't have you have to wait around and come back at 1 o'clock or 1:30 or something like that. So I need everybody to go out in the hallway. And then we will have you come back in at 11:45. All rise for the jury, please. Going through the numbers this way, is that working for you? Perfect. It's, well, something a lot easier. Got big numbers. Are you doing okay? Is there anything that we can help you with?
No, it's just allergies.
No, I get that.
Sniff dust and yeah.
Okay. Thank you, ma'am. I'll be seated. Record should reflect the jury has left the courtroom. Give me a couple of minutes to work through some things here to make sure that got everybody.
Sometimes they'll talk through break. We'll see.
There'll be a day where it'll come.
Thank you again for joining.
Mr. Allen, I don't mean this to be insensitive, but I thought that I had seen this as a piece of evidence somewhere in the case. Was Gannon autistic?
There were only early concerns that he had something like that, but he was ADHD,
Okay,
Yeah.
that's
not autistic.
what I wanted to know. Thank you.
Judge, I don't know if you want to be muted or not, but I just got a text that you are, okay.
Yeah, no, it's still open and it should be. The jury's out, but we should still be broadcasting because it's still open. If somebody wanted to be in the back, that would be okay. So let's see. Oh, but that does raise the question. Are we doing okay otherwise?
Haven't picked up anything today.
So your microphones then they cannot hear you
That's my
over
understanding.
WebEx. Okay.
I can
That's-
check over lunch though.
Yeah, please do. That's good to know. Because that means I can control it from up here and that's a good issue. So let's see. Okay. So as the jurors are not present in the courtroom, these are the additional strikes that I would make at this point in time. You guys ready? Juror 1, 5, 6, 7, 8, 10, 15, 16, 17, 23, 41. And I'm sorry, this is where my numbering gets a little bit off. I jump around a little bit more. 55, 31, 44, 45, 57, 65, 70, 47. So,
Is that last one 47?
pardon? 47 was the last one, yeah. And yes, and actually, I was going to say, I'll go through the list and tell you who I still have left. Okay. I have jurors 2, 3, 9, 11, 13, 14. Let's see, what would that be? Yeah, that's right. They're down on the whole. 18, 19, 22, 24, 25, 26, 27, 28, 29, 32, 33, 42, 46, 48, 50, 51, 52, 56, 60, 61, 63, 64, 66, 69, 72, and 75.
That's the only one that I think you didn't include was 43. I don't think any of us at this table have marked off 43.
43 should be marked off.
Should be.
Should be, yes. If I missed that, I'm sorry. She should be marked off. That is the woman with the striped shirt. It was in the second row back there. Mr. Young?
Yeah, if I may, I'd just like to supplement the record.
Go ahead.
When I was at the bench, I requested that you read the full definition of insanity for the jury. The people are concerned, and I understand where the court was going with that because you were focusing on the culpable mental state aspect of the insanity, but we're concerned that the way the record reads, an appellate court may look at that and say you didn't give the entire instruction. And so we would request that you do that after the break, and I could provide you at least a copy of the instruction that we have.
I have them.
If you have them, that'd be great. I don't know what the defense's position is on that.
I'll ask that in a minute, but I do have the instructions if necessary. But anything else, Mr. Young?
No, just that.
Okay.
Thanks.
Defense, what's your position? Yeah, I'm not inclined to do it at this point in time, largely because what I was trying to do was, and I hope I did a okay job, decent job, in trying to explain that what we try to do in the criminal law is modify behavior for someone who does have the ability to control their actions and chooses not to, as opposed to somebody who acts but doesn't have the ability to control those acts. And I don't, insanity is a complicated area of the law. It has specific instructions for it. And I know that we would be talking about mental disease or defect and moral obliquity and mental depravity and those sorts of things. And I think at this point in time, we would end up instructing people who aren't jurors. So I'm not inclined to do that. I may revisit that depending on how far it goes and where it goes. I understand the jury is struggling with what we understand an insanity defense to be, which is, it actually is legal avoidance. I mean, that's what it is. It is, and I don't mean that in a disparaging way. I just mean that in a definitional way. It is typically insanity is there is an agreement that certain, or an admission that certain acts occurred, but that the law provides an excuse, which is how it's defined. That's legally how it's defined, as an excuse, which excuses the behavior. In this case, that's all I was trying to convey, was that that's what it's for. The defense in this case, I recognize, has the right in every case to require the prosecution to prove every element of the charge that has been brought against the defendant. And at this point, it sounds like it's a tactical decision, and that's okay. There's nothing wrong with that. I'm not faulting the defense for that. It does, however, leave the jurors who are not legally trained in a position of trying to understand and unravel a complex legal issue. So that's it. Mr. Tillini, did you have any other record?
I did, Your Honor.
Go ahead.
I understand that the statute has been previously challenged and been found constitutional, that had the unity as opposed to the bifurcated sanity versus guilt phase.
Mhm.
I think we have some pretty clear evidence that this jury, or the jurors that we uphold, have a difficulty time with that, and specifically difficulty with the presumption of innocence as it goes to the fact phase of the first degree murder. And again, I understand that, but I'm just making the record. It's my opinion that we have evidence that it is impacting the presumption of innocence. And at this point in time, I would be moving to bifurcate the fact element of the trial versus the sanity element.
All right. Prosecution?
And we would object to that. That'd be in violation of the law, and obviously it'd be certainly overturned if there were a conviction in this.
Well, I agree it would be in violation of the statute. I don't know that it would be overturned. It would all depend on whether or not they agree that the statute should be overturned. But the way that the law currently is in the state of Colorado is, and it has been found to be constitutional, is that they are both tried at the same time. I unfortunately had been practicing long enough to recall a time when they were not. So I understand where the argument comes from. But the statute now is that they are tried at the same time and determined by the same jury based on the same evidence. So the motion is denied. You'll have that for purposes of appeal if you choose to pursue that.
And then the only other thing would be my request, Your Honor. I think that the law is clear that the jurors can be informed that they find Ms. Stauch not guilty by reason of insanity, that she would be put in the custody of the department, CMHIP, more or less. I would object, though, to any explanation from the court, any further explanation about what the process would be after that as far as her release or so forth. I think that kind of is getting towards punishment. And I understand the juror was asking the questions, but I would be
I was
objecting that
thrown.
in the future.
I was thrown by it myself. So in the future, I will just explain that there is a statutory process to resolve that, and leave it at that. Okay, so I just want to make sure we're all on the same page. These are the jurors that will be excused, and we will have those other jurors that will be coming back this afternoon. Prosecution, do you agree with the jurors that I read?
Yes.
Defense, do you agree with the jurors I read? Okay. All right, so let's go ahead and bring them all in that we have left or that are gone. Oh, that are gone. Okay. Okay. Still working out okay.
It seems like if you stand up and say, my mind is made up, then you're excused. But if you stand up and say it in a roundabout way, he's going to try to open up your mind. I don't think with everything I know could, or think that I know is true, that I could be open.
Okay. We got everybody? All right. Record should reflect that the jury has returned to the courtroom. Ladies and gentlemen, what I'm going to do is read off the names, or I'm sorry, the numbers of the jurors that will be excused. So at this point, and I don't want you to leave until I tell you to leave, and the reason for that is I want to make sure that I have the right groups. So it would be juror number 1, juror number 5, 6, 7, 8, 10, 15, 16, 17, and forgive me, this is where I start to jump around a little bit. 23, 41, which would be there on the end. 55, which is also on the end. 31. So you, ma'am? Yep. That's a great purse. That is just, I saw that when that was up earlier and I was just looking at it and I was going, what would be even better is if it actually worked. Does it really? No. That's amazing. Okay. I won't have you demonstrate. 31, 44, 45, 43, 57, 65. You know what? It's going to be easier for you guys if I come back there, isn't it? Well, let's do this again. So it would be 5, 7, 7, 7, 7. From either county, anybody that you think that I have missed. For those people that I named or that I gave you the numbers for, you can go ahead and leave now. Wait, before you all get out the back door, is that somebody's backpack? That's yours, okay, no, it's good, I just wanted to make sure that somebody hadn't left, okay. Nope, you're still here. You are juror 27. You're still here. Okay, so here's what we're gonna do. I'll give you a little bit of a plan going forward so that you can see where we're going and what's happening. When we're gonna take a break until about 1:15. And then so if I can have all of you back in the hallway at 1:15 to come back into the courtroom. What will happen at that point in time is that the attorneys will have an opportunity to ask questions themselves. I've been asking all the questions so far. They'll have an opportunity to ask you some questions about some issues that they have in the case. They are limited in time. If they appear to be rushing through something, hold that against me and not against them, because I'm the one that's making them do it. Then what will occur is when we get done with all of that, I may have some follow-up questions, and then ultimately there may be some other people that will be excused. Ultimately, when we get to the end of the day, what we plan to have occur is that there will be jurors that will come back on, we're still in the April 3, right?
Yes.
Yeah, okay. We will have jurors come back at 9 o'clock on April 3, because that's when we hope to start evidence in this case. What you can do when you take your break, I know that you're going to have a spouse, significant other, somebody who may be interested in your general welfare, wondering what's going on. You can tell them that you are in jury selection for this case. You can tell them that it is this case. It is the case against Ms. Letecia Stauch. You can tell them that. You can tell them that you anticipate that the trial, if you were selected as a juror, the trial would last 6 weeks. You can tell them that it may be that you're having to come back on April 3 for further jury action. That is all that you can tell them. You can tell them nothing else. You cannot tell them anything about your answers on the questionnaire. You can't tell them anything about the questioning this morning. And you can ask for their help. Because as you may have guessed, this case has garnered some attention in the community and in the media. If you are selected as a juror in this case, you're going to have to decide this case based on the evidence presented in the courtroom, not on something else. And I'll go into a lot more detail on that if you are selected as a juror. But you can ask for their help to help you avoid any sort of further exposure to anything that has to do with this case. So if you tell your significant other or a family member that you are on this case and they say, I heard all about that and I have certain opinions on that, you can say, please keep those opinions to yourself. Do not share them with me, and help me avoid exposure to those opinions and those things from other people as well. Because, and you can tell them that the judge told you to do that. That puts the burden on me, not on you. I'm married to a woman who has a lot of strong opinions about a lot of things, and she is happy to share those opinions with me, whether I want her to or not. So I will sometimes go home and she'll ask me how my day went. I'll start to tell her, and if I'm in trial, she'll say, what did the witnesses have to say? I'll start to tell her, and she'll look at me, and at some point she'll go, well, you didn't really believe that, did you? And pretty soon I'm having a conversation about what I should and shouldn't believe with somebody who wasn't even here. You can't do that. So to avoid all of that, you just say, the judge said I can't talk to you about it. As I said, that puts the burden on me, because if I were just to tell my wife, look, I'm just not going to talk to you about it anymore, it would lead to an entirely different conversation. So this way it avoids all of that unpleasantness. There is a bistro that's in the basement. There's also, most of the eating joints are north on Tejon. There are a few south on Tejon, but most of them are north. And if we can have you back in the hallway at 11:15, or I'm sorry, at 1:15, we should be able to start right on time at that point. So don't discuss this case among yourselves. Don't discuss the case with anyone else. The only things that you can tell people are what I told you that you can tell them. Thank you. We'll see you then. All rise for the jury, please. Um, Mr. Tellini and Mr. Cook, I don't know exactly how to approach this subject. Maybe you can talk about it or think about it. I would like to find a way to determine if we set the microphone back up on the table, whether they can hear your conversations. But I also,
I can talk to my office and I can
Okay.
put it up there.
Okay.
We should start at the beginning and they.
that's fine. I would just like to know the answer to it so that, okay, perfect. Is there anything else we need to address at this point in time? Prosecution,
No, Judge.
defense? Okay. All right. So we will be back and ready to go at 1:15. Thank you.
All right.
So by my
So pretty interesting. I'm going to let this keep running and get some things done until they come back. Thanks for joining.
Court will call 20 CR 1358, People versus Letecia Stauch. Record should reflect the jurors have returned to the courtroom. Good afternoon, ladies and gentlemen. Thank you for being back so promptly. Takes us a little bit longer to make sure that everybody's here in the afternoon because we have so many vacant seats. So we got to make sure that the people that are supposed to be here are the ones that are here. So appreciate you being here. As I said, what we'll do is at this point in time, the prosecution will have an opportunity to ask you some questions, and their time is limited. So with that, prosecution.
Good afternoon, everyone. Thanks for coming back. It's always a mystery if you guys actually come back in the afternoon, especially after lunch. I'm gonna do my best to keep everyone awake. And the reason why I say that is because I'm gonna be asking a lot of questions of different people. And I'd like all of you to listen to those questions because I may have some follow-up for others. And I certainly, if I ask a question that you disagree with, raise your hand and I'll come and find you, okay? I want to acknowledge this is a very awkward situation for everyone. It's like a job interview that you don't want. And I got to kind of convince you to take the job, right? To be a juror. Maybe that doesn't apply to everyone. I'm just using that to some people, okay? So the rules of the game are as follows. There's no right or wrong answer. It's how you feel. It's what you can, how you want to answer that question. I'm not looking for any particular answer. The only thing I think everyone in this courtroom would like is for everyone to be open-minded. Because we're throwing a lot of information at you and you haven't seen anything yet. You haven't seen the evidence, the facts of the case. You haven't seen the law of the case. And it's until you see the facts and the law, that's when you go back in the room and roll your sleeves up and start deliberating as to what the verdict may or may not be, okay? Is that fair with everyone? Can everyone have an open mind right now? Okay, great. It's also weird that I got to call you by a number. But I want to start with Juror 19. How you doing? You wrote in your questionnaire that you not only are you open-minded, but you should always be open-minded, especially when you're potentially sitting on a jury. Do you recall saying that?
Yes.
What do you mean by that?
Like I said in my questionnaire, my hobby is genealogy. And in order to do that effectively, you have to go in not with a preconceived idea. You have to go in knowing that what is obvious might not be the answer. And so you have to do research. And you do the research, and sometimes you come to the conclusion that was obvious, and sometimes you don't. And so because of that, that carries over in a lot of areas of my life.
So when you say research, it kind of makes me a little nervous, okay? Because you can only base your verdict on what you hear in this courtroom.
Right, but I'm just saying that's from a genealogy standpoint. I have to do the research. So that's what's created me to not preconceive an idea.
Okay, great. Does everybody agree with that?
Yes.
No. Okay. I think you got to raise your hand because I'll drive the court reporter nuts if there's a million yeses on the transcript. Okay. Does anybody disagree with that? Okay, great. No hands. Juror 19, I'm going to follow up. Does it surprise you that this burden beyond a reasonable doubt is the same burden in every courthouse in the United States?
Surprise me?
Yeah. Be surprised, maybe not the word I'm looking for. Would you be safe to say, is it your knowledge that that's the same burden in every courthouse?
That too.
So it's been like that for, gosh, almost 250 years now, right?
Right.
And so what we're talking about is nothing new. Jurors have been getting together and using this reasonable doubt standard seeing what the facts are, applying those facts to the law, and rendering verdicts. Does that make sense to you?
Yes.
Does that make sense to everyone? Okay. We're not inventing the wheel here, right? Jurors have convicted people with this standard and acquitted people. Is that fair to say?
Yes.
Okay. Can you do that? Can you follow that standard and weigh the facts and apply the law to those facts and render a verdict, whether that's not guilty by reason of insanity, or guilty?
I believe I can.
Can everyone do that? Raise hands if you can. Okay. Can anyone not do that? Okay, I'm gonna pick on juror 72 back in the back. I didn't see your hand go up either way. What do you think? See what I was talking about? Sure.
Why is it important for covered and sorry?
Sure. Can you apply the standard of beyond a reasonable doubt and render a verdict based on the facts that are given to you via the evidence and weighing those facts with what the law says?
All the instructions given by the judge.
And I want to talk about something you put in your questionnaire. You okay with that? You're not a big fan of police officers.
No, I despise it.
Can you see why that may make me a little nervous?
That's your problem. Who wants the problem?
Well, I mean, can you be fair to both sides?
It depends.
Okay, tell me what you think.
Right off the bat, no, because I've seen police.
So do you think that's going to cause your ability to be a fair and impartial
If you're
jury?
about emotion and you like that, then fine.
No, I'm not saying anything. I'm just trying to figure out what you put in your questionnaire and whether or not you could be a fair juror. That's fair?
Have your call.
Well, I'm asking you, could you give us a fair shake?
I don't know, man. I don't like courtrooms. I don't like the system. I think it's.
I'm gonna leave you alone. I'm not gonna ask any more questions. Does anybody agree with what juror 72 says? Thank you. Anybody disagree with what he says?
I think it's a shame. That
What
it
do you
feels
mean by
like,
that, juror number 2?
I just feel like he's had so many things that have happened. And it's a shame that he's had to go through those things that has soured him to where he feels that he can't be impartial.
Juror number 3, how are you doing? That's strong a little bit. I'm gonna ask you a question. What would you say if I said you've been training your whole life for this moment? You'd say you're nuts, right? You know what I mean by that?
We're all part of the United States, and that's part of our duty to.
I'm gonna help you out. You don't ask jurors to leave their life experiences at the door when they come in. Your life experiences is what makes you a person, right? See how that question might mean something now? Yeah, no? You just don't want to talk anymore, do you? That's fine. But would you agree with me, though, that you don't leave your life experiences at the door when you come in? But what you can't do is base your life experiences in rendering a verdict. You have to base it on the facts, the evidence, and the law that you get. Can you do that? I'm going to talk to you now. You're number 11. What do you think?
Don't leave your experience. Set your emotions aside and consider.
And along with those everyday life experiences, you're going to have sympathy, especially in a case such as this. And the question I have for you is, can you put that sympathy aside when it comes time to go back and deliberate with your other 11 jurors as to what the facts are and whether or not the facts fit with the law and render a verdict based on that? Can everyone do that?
Yes.
Are you saying you can do it? Did you raise your hand? Good. Number 13, I want to ask you a question about the sympathy aspect. It also applies to the defendant. You can't have sympathy for the defendant. You can, but you can't let that interfere with your verdict. You okay with that?
Yes.
Is everyone here okay with it? Let me see a show of hands if you're okay with that. Great. You're 18. How are you doing? Wonderful. Does it surprise you that one of the ingredients or the elements of the crime not include motive? And again, you haven't seen the instructions listing the elements of the crime, but could you see why it might be difficult for us to prove motive for any crime beyond a reasonable doubt?
Basically, I'm here for you, to present your evidence to me. I can make a mind on both sides.
You understand the burden of proof is completely on us. They don't have to do anything. They're gonna do something, but they don't have to do anything, right? Right. If they choose to put witnesses on the stand, you understand that we get an opportunity to ask them questions as well. And we get to do what's called cross-examination. And we get to cross-examine, for instance, if they choose to call experts to the stand. And are you going to hold it against us if we challenge those experts and the opinions that they may bring to the court?
That's your job.
That's their job to do that as well, right? If they choose to do so. And when we talk about sympathy, are you going to have any sympathy for any witnesses that are called to the witness stand because they may be cross-examined? Might be kind of tough on them. You're number 9. How are you? You're a judicial assistant? Where are you at? All right. Well, do you know us then? Nothing that's going to interfere with your ability to be very impartial? But you've been following and you know everything that's going on as far as the jury selection process. Yes. You know that the burden of proof is on us. You know that this case involves a murder of an 11-year-old. You know that there's going to be autopsy pictures, right? Why is that? Do you think that's something that would be necessary for us to do to meet our burden beyond a reasonable doubt?
I wouldn't know necessarily the necessity of it, but I would.
Do you think the manner of injuries to a person can dictate the state of mind of the person who caused those injuries? Let me use an example. Say you're on a jury for a shooting. The person who shot someone else aimed a gun and shot him in the foot. You do that differently from them aiming a gun and shooting them in the head. Did you see the difference between what the two intents may be?
Yes.
What is it?
More of like an accidental.
Do you think that might be an indication to show whether or not someone intended to kill someone? Whether they shoot him in the foot or shoot him in the head? Okay. But
I do understand the difference.
does everybody understand that the differences between that? Because as the court said, one of the things we have to prove is what's called the mens rea. What was going on in the defendant's head when the crime happened? What number are you, Gail? My glasses are broken, just as goes figure, they'll break during this. You are juror number 27. How you doing? Do you think actions sometimes speak louder than words? Mean it.
Or just kind of breathe. It- it's enough.
Would you agree with me that sometimes actions speak louder than words if you don't have any words? Sure. Just give me a second. What was my intent just then? Do you think my intent was to get a drink of water?
I don't know. Were you thirsty?
All right, let me ask, is your 26, is that your number? What did you think my intent was when I got? What?
Stop.
The stall?
Get rid of
That, how did you determine that? I didn't tell you I was stalling, right?
it. It was on the context.
So if it was a crime for me to stall, would you be able to develop my mens rea, the intent to stall, based on what we do? Tricky, isn't it? It's like one of the MCs used to say, tricky, tricky. You're 25, what do you think about that?
There could have been lots of options. You could have been first. Could have been strong. I mean, I agree with some of them, but making that decision. And from action speak.
Well, I'll change it on you. You see me going to, what grocery store? You're King Soopers, you watch me walk in. See me go in the soup aisle. You see me go to the bottom shelf and get tomato soup, which I like. Take it out and go buy it. You don't talk to me, you don't know me, you don't know anything about me. Develop my mens rea based on what you say. Well, could you say, hey, that guy must have wanted some soup? You know what I'm saying? I'm going nowhere with this now. I'm gonna change topics.
Or know that you're getting, I mean, I would see that you're getting soup, but it would mean nothing to me.
Got it. Now, I want to talk a little bit about legal insanity, okay? We talked about that. And I want to pick on a couple people. Juror 64, how are you doing back there? You bet. And you are in that field, right, of mental health. And so do you know whether or not legal insanity is a mental diagnosis?
I would say so.
Okay, why do you say that?
First of all, I do not, my personal opinion, I do not believe in. And there's reality, right? So
Mhm.
maybe they might have paranoia delusions, but.
And I probably did a horrible job of asking the question, but legal insanity is a legal term. Lawyers wrote it. You won't find that in the DSM-5, right? It's not a mental disease or defect or a mental disorder. Does that help clarify a little bit?
Yes, what I'm saying is, it might not be legal, but in reality, person can be totally disabled mentally. Fine. At that point, there might be the legally thing insanity.
Sure. And I understand that, no question. But do you also think there's some people who have mental illnesses that are legally sane?
Well, absolutely, most of them are.
And what do you say to that?
Most people, they know what they are doing. Might be kind of odd, but they know right from wrong. And that was good delusion, so it's psychosis. They might do.
And is that something that is obvious when you see it? What?
Most people, they are not.
And how do you go about making a diagnosis like that when you talk about psychosis, for instance?
We normally talk to them. First time that I get their overall appearance, and then they really having psychosis. Severe cases.
Thank you for that. I appreciate it. Juror 51. How you doing? Bet you don't know where I'm gonna go on that, right? Would you agree with what juror 64 said?
Yeah.
Okay, then I'm not gonna go through the whole thing with you. Would you agree that, oh, well done. Can both of you, let me ask you, follow the instructions of law as it goes to legal insanity? And not and put aside what you may have experienced in your professional capacity?
Because I am on. Sitting there trying to assess the case. To the defendant, right? So. Also, I'm having to learn more into why she did it. Of course, it's, my knowledge. I can put aside, I will not put that as the my profession.
And I'm not asking you, I'm just, the instructions that you get on what legal insanity says in the state of Colorado is instructional law. And I'm just asking if you can follow that despite what you may have heard or read, for instance, in other states or something like that with regards to legal insanity.
Then I can do.
Okay, and I'm not asking questions very well. I apologize. How about you? You're 51. So. Juror 50, how are you doing back there? I don't think we've heard from you yet, have we? One of the things that is defined in the definition of reasonable doubt says that you're not allowed, or you can't speculate as to what doubt is. It's not a speculative doubt or vague speculative.
Kimberly, can you hear her?
And you can't assume facts that you don't hear out in trial. And you can't say, well, this must have happened You hear about it, you can't use it, okay? The reason, well, you tell me, why do you think it's not beyond any doubt? Burden. If you don't see it for your own eyes, would you be convinced without any doubt? If you actually witnessed the crime, you may have that beyond any doubt, but you wouldn't be a juror, right? You'd be a witness. Do you think that's reasonable to have that standard? Can you
Sure,
repeat
50
yourself,
if you could.
please?
You just ask what the best.
I don't think so. How about you? Have you ever been 100% sure of anything? No. Goes back to your son. Dude, how are you? Probably don't want me to ask you any questions, right? Hey, does 1 + 1 = 2? All right, this happens every time when I pick a juror. We have juror 28. Oh, no, I'm sorry, 20 or 29. Juror 29 said sometimes. But juror 29, why is 1 + 1 not = 2? If you saw my math grades. Is there any engineers left in the panel? We have an engineer. Okay, coming over here. Juror number 11. Why does 1 + 1 not always = 2? Well, every other jury I picked, I got this right, but this one I didn't. But even math may not be on a reasonable doubt is the point I'm trying to make. Okay, at least you don't know why, but you may have some doubt as to 1 + 1 = 2. Is that right, juror 29? I think that makes sense why it's beyond a reasonable doubt. Does everyone agree with that? Yes, okay. I want to go back to juror 66. How are you doing? What are your thoughts about all this? The reasonable doubt, burden, legal insanity, natural gas. That's what you're thinking about, right? Talk to me about that. It sounds like you provide natural gas or you help facilitate that for a large number of people. How are you going to do if you're on this jury? I'd take it over what we got right now. Why didn't you say something before? You don't even hear it out there. Right. I appreciate your eloquence and your response, because you're right on.
Totally off the question, right?
No, that's what I'm looking for, because we need to know that. And, you know, I'm sure no one in here is comfortable judging any of it. You know, that's not what your role, that's not what you woke up this morning to do, right? Even though you had a jury summons, but you get my point. Does it help to know that you are really judging actions? Don't have anything to do with any potential sentencing? You're basically, like you said, you and 11 others are determining what the facts are. You and 11 others are determining how those facts apply to the law. And if you can't do it, there's nothing wrong with that answer. But if you can do it, let us know.
That's my understanding.
That's the problem with this whole process, because you don't have all the information, right? We're asking you hypotheticals, and we're asking you, you know, what your thoughts are. And that's why it's difficult. It's really difficult to pick a jury, because I can't come out and say, hey, here's my facts, here's the law, what do you think? You'd make a fine juror. You know, I can't do that. And so you're the only one who can tell us. I'd like you to think about it. And if my time is out, maybe you can tell someone else what your thought process is. But if you do come to a solution on that, raise your hand, I'll come back to you, okay? Betcha. Juror 69, how are you doing over there? Yeah, that's what I'm calling on. Yeah, well, tell me what you think. What do you say? Seven and a half years of school, what am I gonna do?
Big decision.
And I just want to, I want to clear up for everybody, the fact that she's pled not guilty by reason of insanity doesn't take our burden away for the charges. We still have to prove beyond a reasonable doubt that first, the crimes were committed. We also have to prove beyond a reasonable doubt, if those crimes were committed, that she was legally sane at the time she committed the crimes. But I mean, are you okay with that burden being Right. But Russell Wilson. May have someone describe him as being the best quarterback I've ever seen. You have someone else describe him. Are you kidding me? He didn't make one good pass the whole game. Same game, two different perspectives, right? You think that happens in real life in criminal cases?
I have a version here.
If you can just speak up a little bit, please.
Sure thing. So yeah, with perspectives, just kind of the way that.
And so when you're talking about a criminal case, you can look at all the evidence as a whole before you come in and weigh someone's credibility.
Yeah.
Because what happens is we can only call one witness at a time, right? So you may be weighing that witness's credibility each time we call a witness. But you really can't base the verdict until you go back to the rest of your jurors and deliberate and then look at the evidence as a whole. Can we do that? Can everyone do that?
You have about 2 minutes.
How are we doing back there? I forgot your number already. Let me come back to 66. What are we doing? All we can ask of anyone is do the best you can under the circumstances. Because, like I said, I can't tell you how it's going to go and what's going to happen. You're the only one that can tell me how you're going to react to evidence coming in, applying that evidence to the law. And I'm going to ask you outright, if we meet our burden beyond a reasonable doubt, you feel like she's guilty, can you come back and render a guilty verdict? Flip of that. If we don't meet our burden beyond a reasonable doubt, you listen to the entire case and you say, I don't think you got it. I'm not satisfied beyond a reasonable doubt. Can you find her not? About with an open mind. Okay. Can everyone do that? That's all we're asking you. If you cannot do that, raise your hand, please. Okay, those are my questions. Thanks so much for your time. I appreciate it.
Before we get to defense question, I wanted to do some follow-up on an issue. Juror 56, you had put on your questionnaire that your husband was having some surgery. And you were unavailable on April 3 and April 6. I'm sorry? Okay. And what date is the surgery? Let's see. Oh. So the 6th is a Thursday. Is he going in for that day or? Okay, and what's on the 3rd? Oh, all right. And is he going to be done on one day or, I mean, I'm trying to stints. Really?
But it needs to be done.
I mean, just from my perspective, stint sounds bad.
Yeah, it's not good.
Okay. Obviously, we would be starting trial on April 3 if we can, if everything works out the way that we think it's going to, or hope that it does. Are you going to be able to be here on April 3? Okay, the 6th is a Thursday. We don't have trial on any Thursday. But I am a little concerned, are you gonna be distracted on, like the 5th or the 7th or anything like that? Wondering about, oh, he's going in or he's just gotten out, I should be home with him, anything like that? Okay, okay, all right, I just wanted to follow up on that. Okay, thank you. Mr. Tellini?
How's everyone doing? Good, okay? All right, I hate this part of the trial, the beginning part when I can't talk, so I'm glad we're finally into this part. And again, I want to thank everybody in this room for coming back after lunch, after hearing what this was going to be about, and after hearing how long we might keep you. And I want to start off first about talking what this portion of the trial, this portion of the proceeding is, jury selection. Sometimes we call it board ire. That's just lawyers like to use fancy words to make sense, make it seem smarter. Voir dire simply means to tell the truth. And we had a juror, I think she was juror number 57 over there, and she kept apologizing because she had these preconceived ideas because of the media and everything, and kept apologizing for not being able to put them out of her mind. But what I want to tell you, ladies and gentlemen, she did exactly the right thing. You guys have no other obligation right now, other than to be honest, to talk about where your heart is right now, talk about where you're sitting right now. Nothing else like that. We're not asking you to change views. We're not asking you to do anything impossible. Just tell the truth. Can everyone just be honest and tell the truth? Everyone can do that? All right. A lot of people express this in some different ways. Who has right now, looking over there, at a position where they think Ms. Stauch is guilty? Okay, we keep doing that.
I'm sorry, could you repeat that?
That you think she's guilty, but as you're saying it right now, you're coming in thinking she's guilty. And so when they're saying, they're asking if your mind can be open, Ms. 27, what I'm kind of getting the impression when you said you could be open, you can be, you think she's guilty. Maybe I might be able to convince you otherwise, but as you sit now, I'm going to have to do a work to convince you something different. Is that accurate?
Your response. Correct.
Mr. 42 saying. 32. Did you raise your hand?
I did not.
Oh, okay, well then, okay. 60 though, that's, I mean, I really got that from you. Based on what you've seen, everything, you think she's guilty. Your mind might be open, I might be able to convince you otherwise, but right now you're thinking I would have to overcome. 66, you're nodding your head. Okay. You can't presume her insane right now, or presume that she would not go with that reason insanity. Right now, you think she's guilty, and I'd have to do a lot of work. Okay. Who else raised their hand? 56. Do you agree with 66? Pretty much in the same position. Okay. I mean, I'm behind the 8 ball right now. Okay. 63. Yeah, that's you, sir. Sorry. Same thing.
I was in Puerto Rico at the time when I came over here. All I had was my family trying to say no.
Sir, what's your bad luck days? Okay, but as you said right now, based upon all you've heard about before you came in this room, I'm behind the 8 ball. You can keep an open mind, but I'm gonna have to convince you. Pretty convince you still. That the insanity is much. 61. Same as him. 69, I didn't see it. Did you raise your hand? Okay. Oh, you, okay, I'm saying. Okay.
Overwhelming.
Okay, I would have to overwhelm you with evidence that you can say it's not, okay. And so if the law was, that it's actually, they have to prove overwhelming that she's saying, you can't apply that law when it's a dead kid. Okay. Or at least where you're sitting right now, I would have to overwhelm.
I'm gonna have to say, for my mayor.
Okay,
Yeah.
okay. Okay, and as of right now, I mean, it's only it's 100 minutes.
Had a son, she really done insane and then. Because of the brutal, that's all crime she committed.
Yeah.
I'm thinking, how can a person in my mind can do that without any type of. That's kind of that's that.
Okay. Well, does anybody else over here who's with jury number 66? And again, it's all you guys, no, thank you for your honesty. That's all we're here for right now. Folks is kind of saying the same thing. Like, be open-minded, boy, he's gonna have to do a lot to overcome how things right. 33, feel that thing. 48? How are you getting? $30. 29, where are you at? All right, you can yell at me.
Council, hold it for just a moment, please.
Sometimes I stand on one issue. Oh. It's like,
That is.
I get fearful, angry.
I was saying that, I would have to hear all the evidence on both sides before I make up on, and I can't say right now she's guilty. She's not. Once I hear all the evidence, I weigh all the evidence. And. Figure that out.
It is, but in criminal case, Constitution, process clause, requires it right now, actually through the course of the state. 28. All right. Like, where are you at? Are you, some of the girls say, right now, baseball, I've come in here with what I've seen in the media. I'm thinking that she's probably guilty. Maybe you can convince me otherwise, but that's where I'm sitting right now. Or are you in a position, I think she's innocent, think she's crazy.
I have never heard with the media. This is the first time I'm hearing this case. So. Both sides.
Okay.
So I have both my mind on both cases. I've not. So. I'm like, I'm not.
Eric, I get a 10-minute one. Over here, everyone's kind of getting where I'm going at. We've heard some people say, hey, I can kind of keep an open mind, but as I sit here, I think she's pretty guilty. You're going to have to do a spectacular job and overwhelm me. I mean, and I appreciate jury number 66 and 60 when they were asked, like, yeah, I can find her guilty. If you find her not guilty, was hard. And that was a great honest thing, but how many people over here are kind of in the same position at 60 and 66? What? No. It was just, yeah, no, and I really appreciated your honesty in the way that you did that. And so sometimes yours oftentimes articulate things better than I am able to. And so like, I appreciate that. And like I said, right now, honestly, and this is a hard case, ladies and gentlemen. We're planning on being here for 2 weeks before we finally get to a jury that we can pick from on April 3rd. But all the people in suits here know that this is going to be difficult. It's 8 weeks of people's lives. That's not easy. Got other stuff to do. We got a ton of media on this thing that makes it a lot more difficult to presume somebody innocent. We've got a dead kid who was murdered horribly, badly. Everybody gets emotional about that. Everybody should get emotional about that. And sometimes a lot of people can't put that emotion aside. I don't care. And then we've got insanity. which a lot of people have a lot of feelings. We know that this is gonna be difficult, and all we're asking for everybody to be honest, okay? That's what I want everybody to understand, that there's no bad answer. I'm got nowhere else to be. We're gonna be here. 52, what do you think? Yeah. Now, good, I'm glad that you said that, okay? Because criminal trial is a little bit different than any other type of case, in that the burden of proof. Say, we're out and I'm driving, Mr. Cook, rear ends me from behind, and I said it's my fault, I say his fault, we go to court, it's a civil case. And it's just by what's called a preponderance of the evidence. And you just got to decide, more likely than not, who was, at fault. And that's kind of the, for civil case. Then like sometimes when we have, there's an allegation of, of child abuse in the home, kids aren't being fed properly or taken care of properly, what's called a dependency and neglect. And before the kids can be taken out of the home, it has to be proven beyond what's called clear and convincing. Up to you, lots of things. But another thing is, clear and convincing is somebody has a strong belief. I have a strong belief that Lee Harvey Oswald acted alone, but somebody else may think there was a conspiracy. I don't think they're in that case. I don't think they're unreasonable. I just have my strong belief they have a different. Beyond a reasonable doubt is the highest standard that we have. It goes all the way back to Rome, the standard. A lot of stuff go back to England, let's go back to Rome. Rome, it was interpreted in Latin, clearer than day. That I know that the earth is round. What says the earth is flat, I know they're unreasonable, okay? Beyond a reasonable doubt, I know the earth is round. Someone says something different, you're not kidding. Okay, so this is something I'm sure of. Something I would not hesitate to act in matters of importance to me. With a standard that high, what that means. I've had this happen before, they're gonna endure. They go, you know what? Y'all had a strong belief that your client did it. Weren't sure. They didn't know they improved beyond a reasonable doubt. And we had to vote not guilty. Can you do that in a case like this? Juries. I know it was a long time ago, but I'm sorry. 51. Well, you might go back there and go, boy, I think she was saying, but it's possible she wasn't. And you're in that position, you have to vote not guilty by reason of insanity. And you do that. And that's what, and for you and your number 64, you both have training. And we don't want you guys just to leave that at the door. I mean, you guys can take that and you guys can use it in kind of, what you think of the expert or the different experts coming. What would not be okay for you to go back in the jury room and say, oh, based upon this textbook that I had reviewed, whatever, this expert is wrong. You can have your opinion, but to tell people tell the jurors what other things from outside the courtroom would not be proper. Are you okay with that? For 64. Back over here. I know the judge asked everybody what they thought about the not guilty by reason of insanity, and some people were shocked. They're number two. You indicated on your questionnaire that you feel that not guilty by reason of insanity is an excuse.
Well, that was the one thing I wanted to change after listening to everything you guys had to say today. I had mentioned it early to someone that I felt like maybe it wasn't a good idea that I just give it a blanket like that. I've never had, I am unaware of this case completely. I have always felt in my heart that there wasn't such thing as a plea for insanity. I think we're all a little nuts, but I just felt like after listening to everybody and opening my mind up to the possibilities, that it could be something I should be open-minded like everyone is saying, and I would do that.
You would do that? Okay.
Yeah, I would.
I know number three, you have some issues with the insanity.
They're insane just like after the fact.
Yeah.
But if they've had serious issues beforehand, then
Yeah, and I'm not asking you to prejudge this at all about whether or not you think she's gonna be insane or not. I guess I'm more towards just the defense itself. And I guess here's the thing. It is an affirmative defense in the state of Colorado. It's there with statute. And I think an easier thing to kind of compare it to is self-defense. You know, again, if I went up and I just went over there and I punched Mr. Allen in the face, that would be third-degree assault. I've done it, okay? But if he had said, you know what, I hate Josh, I'm gonna go punch him in, and I see him walking towards me with his fist like that, and then I hit him in the face, that would be self-defense. So it's an affirmative defense, even though I did the actions. The state of Colorado has very specific things for must apply. And if it do, then that's not guilty. And insanity is the same. If we meet these criteria, once we raise it, they have to disprove it beyond a reasonable doubt. They have to prove, you know, she's safe. Are you okay with it? And because and kind of on like the self-defense thing, there's sometimes I'm not okay with that. It's self-defense applies whether it's a man or a woman, okay? I've raised my boys that there is never any justification to hit a woman. That if some woman comes up and hits them, they need to take it and they need to get out of it. That there's no excuse for that. And so if I was on a trial where it's a man and a woman and he's claiming self-defense, I'm not going to be the right juror for that because I don't believe there's ever anything. So kind of what I'm trying to get the point. I'm trying to find out if there are jurors that feel the same way about the insanity defense as I do self-defense if it's a man hitting one. No? Okay. You look puzzled.
It's gonna be challenging.
It is.
Paperwork today and write down whether she's guilty or innocent. That's. Well, I'm struggling with that. It's tough, but. What I look at is that's what our country is based on,
It is.
is justice. We have to, whether you like it or not, we have to go in with our view.
Well, I guess I think that's a great point and a great thing. You know, we have like Lady Justice and she's blindfolded, you know, and we're supposed to have the same, you know, you'd agree, we're supposed to have the same standard, whether someone's accused of stealing a candy bar or a murder. You know, the two people should stand before that jury the same. And, you know, one of the things they're supposed to stand before is, you know, they're supposed to be presumed innocent, you know, when they come in. And I think it's hard. Everybody knows it's hard when there's this much media. And again, I can tell you, everybody in suit, Mr. Gradiano and the judge, we would all much prefer there had been no media, you know, on this case. Because it wouldn't be this difficult. And I think you understand that she has a right to be presumed innocent. And so I guess what I'm asking you I'm getting, and again, if I'm misphrasing something, I'm getting from you, I know what I need to do, but because of, and I can't help the facts of the accusations or the media or anything like that, you're hesitant to say that you can do it.
I like to believe I can. I believe I can put on that line for justice. Under the decision that I
Feel confident that you can, or do you just feel hopeful?
What's with you?
Yep.
I think
Okay, that's what I want. Number 13, I know that you have some issues. Well, now keep everything the same.
I do.
Okay.
I mean, to me, it's kind of, if she didn't do it, then she pleads innocent, right?
Yeah.
And the fact that she said innocent by reason of insanity tells me that she did it, but I did it because I'm insane, right? So they do their job and they prove that she killed him. And then you do your job by proving that she was insane. I mean, you both won, but we don't have a verdict that says she did it, but she was insane.
That's what, if
You know what I mean?
not guilty by reason of insanity, right?
Right.
She did it.
Yeah.
So if you don't think she did it, it just be straight not guilty. If you think that she did it. but
It would
that
be
she
a lot
was-
easier if the insanity thing wasn't there.
And so, look, and all I, and you know, like I was asking Mr. Levin here, I'm hearing from you.
Right.
Like if this was, it would, you know, an alibi, she wasn't there, didn't do it. These concepts, presumption of innocence, beyond a reasonable doubt, easy.
The problem that I have is when the judge says, okay, look, from point one, everybody's got to think that she's innocent.
Yeah.
And that's a true statement, except when the fact that she says by reason of insanity, that leads to the belief that she did it and she's using the insanity plea to explain it, right? I mean, the fact is the boy's still dead.
Yeah.
That's the hardest part about this all, is he's dead. And I don't know, my biggest problem is if they prove that he was killed by her, and then again, you prove that she was insane, he's still dead, right?
Yeah.
That's where I'm trying to wrap my mind around the whole thing. The innocent piece is what I mean, you know, is the innocent by reason of insanity. If I could say, well, she did it, but she was insane, so there was a reason. You know what I mean? But innocent tells me, in my mind, that she didn't kill him, that the boy didn't die.
Is a drug beard. Let me ask you this. Also,
It's like a ping pong ball going
Go
around.
back in your head.
Yeah.
I'm going back in too. Yeah, your questionnaire, you also said you thought she would be.
From the media and from sitting through this, it's got me to realize and open up my mind a little bit. And I mean, we had a former president that always liked to say fake media, right?
Yeah.
So fake news. That probably applies in a lot of cases here, right? I mean, I don't know what channel I was watching yesterday, but or a couple days ago that said that you know, the psychiatrist had found that she wasn't insane. But I'm sure you're going to come up with one that says she was.
Yeah.
But the news didn't say that, right? So, yeah. There's always two sides to a story.
There is. And I kind of, I'm going back to, I'm just trying to figure out like where you're at. I know like if you can, and it's confusing and there's a lot of legal jargon and everything.
Right.
But to be a juror, I like the all I'm asking honesty, you have to presume you're innocent. Can you do that or do you have some reservation?
I would like to say that I could do that. I would like to believe that I could. But the answer is I don't know.
Juror number 14, I know you had some issues with the exam. Not insanity, you had that the news had influenced your opinion.
Well, it has a slant.
Okay. Yeah, like that.
To me, right now, It's like you were saying, Lady Justice.
Yeah.
For me, the scales are balanced.
Mm.
Either side right now in my mind, except for what I heard on TV, which has a slant.
Yeah.
I can put that aside and look at the balanced scale. That's how I see it.
Ryan, you've been here, you've heard all about this case. How's that impacted you?
I'm much. Just see. This position.
And I worry, just because you're here. Don't think this wrong. I worry that you'll worry. Your decision is going to be, second guessed and talked about and everything else. I get, let me put it this way. We've heard from all of the jurors. A lot of people have come in here, seeing the media and everything like that. Preconceived notions. She's guilty, Sandy's bunk, everything like that. My guess is there's a lot of people in the courthouse who feel that same way, and you're gonna be around them, they're gonna be asking, if you were to come back not guilty by reason of insanity, how could you do that? Is that a weird thing? I think when you, I don't know.
Honestly, we don't talk about.
Okay.
cases very much. I mean,
I know.
people, so we don't talk about. A lot of friends that we talk about with somebody.
Yeah.
But.
Juror number 18, what do you think what are your feelings on the insanity? Not guilty by reason of insanity.
Here to hear the evidence, first of all.
Yeah.
I heard a little bit on the news. News to me, other things. From today. Follow on to Florida, I didn't know any, so. Very interested to hear both sides of the story.
Juror number, what's 24? You put down that you think that the not guilty by reason of insanity is a ploy.
Yeah, I did, but as you read through the rest of my stuff.
Yeah.
you See my background a little bit.
I do.
I've been on that side.
Okay.
I'm on this side, been through the system and stuff like that, but when the judge was talking about, the media giving the one side, is the media giving the facts?
Yeah.
Is that you're hearing that one side, all that other stuff? It automatically clicked on me, because I teach I'm a superintendent for a construction company. I lead my guys, I lead baseball leagues, I talk in churches, I do all kinds of, from my experiences. But for me to put down what I did, I cheated the system in doing that. And when against what I go out there and try to promote by not hearing both sides.
Yeah.
So, yeah, what was it, the reason I'm saying?
Yeah, you
My way I look at the reason of insanity is actually kind of elaborate, I think, on what the gentleman down here was kind of going back and forth.
Yeah.
If you're of your normal mind, your right frame of mind, even doing something like that, you're knowingly, willfully, and you know exactly what you're doing.
Yeah.
So the insanity plea would come in, I think, if you actually did not, understand or know that what she was doing. That's how I differentiate from the two. But I mean, there's been where I've been and seen the actual people inside on the other side of the fence, in the yard and all that stuff. I mean, I'm no expert because of the book.
Yeah.
But I have firsthand knowledge of seeing these people. Hearing stories. But to say, no, she's guilty,
And I guess what my worry is that I think a lot of people never got killed by reason of insanity. Oh, kind of a last ditch, employee trying to get out of something. This is kind of an excuse. Mindset. And that mindset is actually the exact opposite that a jury needs to sit in if they're going to be. And I'm kind of hearing from you if I'm wrong, that you kind of came in with that mindset, but now it kind of readjusted.
Oh, yeah, I am. And that's because, when the judge was saying it, I'll see what the media did, and all that stuff. So me putting that down without hearing both sides, putting it right in, all that garbage. Okay. I can do that. 66.
Just one quick follow-up.
No, absolutely.
Yeah, I don't. You probably will.
Good work if you can get it.
Yeah.
In- All that's necessary.
That's good. Because it's here, we have legal axioms and everything like that that are good in books and everything like that, but in practicality, it's not the way I work. They're gonna be presenting it. We're gonna be fighting them too. We're gonna be doing everything that we can, okay? Well, I'm not gonna sit, I'm gonna fight, I'm gonna do everything. The only person, look, I like everybody here, but that's the only person I believe in, is right there, and I ain't gonna fall. And I'm gonna do everything I can to help protect her, okay? But the law, what it does is, it kind of like, ground rule for, court, it requires you to start over in this position, way over here at not guilty. And it's basically kind of like a football game. They've got to drive the entire length of the field over that goal line. They get stopped, at 90, the 2-foot line, game ends, it's not guilty. It doesn't matter if they drove 98 yards or not, that's what it is. What I'm kind of getting from a lot of people here is that they're not necessarily starting on their goal line because of the media and everything else, or the facts, or the graphic nature of the charge, everything like that. Maybe they're starting at 30, maybe they're starting at midfield, something like that. Brother. Yeah.
It would be insane.
Let me just say,
You know,
do some stuff.
yeah.
You're number 50, Mr. Young, talked about it a little bit. It's not gonna be an easy job. And if you're gonna be chosen to be on this job, you're gonna have to see outcome. Autopsy. Photos of the 11-year-old kid that had been in a suitcase for over a month. And the way that the injuries occur are gonna be important, they're gonna be important for both sides. I think a lot of times us over here forget the impact that has on people because it's just our job, we have to do this, all the time. Are you gonna be able to do that? I'm not saying you don't have an emotional reaction, I'm not saying you want to do something. But are you gonna be able to do that and then put aside your emotion and look at those photos for what they say, or is it gonna be something that experience is gonna be so emotional that you're not gonna be able to look at a fraction? Oh, 75, right? Let me see what it is.
That's
Yeah.
right. It's 75.
75. Sir, no one's asking anything.
10 minutes, Mr. Tellini.
What do you think about all this?
Mr. Tellini.
Yes, sir. Thank you. All right, I'm gonna circle back around. Some people put some stuff down in questionnaires. I want the judge to ask about some difficulties. Juror number 2, you have insomnia?
Yes.
Do you think how will that impact you? Sorry.
The clarity, just because I've been going through this for years, I don't get enough sleep, so by this time, day is usually when I go to sleep.
Okay,
So 2 o'clock is usually the magic hour.
so,
I'm fresh in the morning, even if I haven't had sleep, but for some reason, right around 2:30 is when it hits me. So anything that I'm taking in, might be hard to really take in.
okay. Number 25, you said you're unavailable on Wednesdays? In April, yes.
In April, I've got some appointments, but I'm thinking
Okay, so do you think, and weren't you also going on a trip?
maybe
Okay, and that's in stone, and so if,
I could move it, but I would have to move it like to now.
okay. All right, number 33, where's 33? Oh, right, you have some work issues that you think that if you're chosen to be for 8 weeks out, financially work as well as
connections. Part of the legal stuff.
maybe we can, I mean, we can delay that until the end, but what I'm worried more about, if you're chosen to be on the jury, you're not gonna be able to work nights. You're gonna be able to survive financially. Number 42, you said you're unavailable April 10th through April 11th?
Yeah.
46, and this make it very difficult for you to do your job.
Well, 10 stores that I see their guys.
Okay.
Each store has. And if I have somebody.
Also, the type of thing that I might be able to make you sit here for 8 weeks, but if I might be going to places.
I might. I can tell you, I've heard everything that everybody says. Okay? I have not thought that I've told them. Everything that one is saying. That I.
No, it's more, all we want is the truth.
So. Earlier there was discussion about, judging. I think we all judge people. Extent might differ.
we all judge each other every single. So, we come in and ask.
Okay, I'm sorry.
Come in and ask questions about whether or not we have or haven't, or will.
Already, yeah.
Yeah, not necessarily a made up mind, but we've already judged. Not just about everything. Not the judge.
I'm not asking good.
About each other. I think everybody has made a judgment.
Judgment thing.
I don't know.
Did you make a judgment?
Judgment isn't necessarily about serving. But may or may not. Judgment isn't about innocence or guilt. About character.
What's your judgment about a person?
No, I'm not gonna allow that.
Is your number 51, sole provider for your family? Oh, that's right, how difficult is this gonna put your family out? What's if you're here? Okay. Yeah. That's why I'm asking. It's okay.
I know.
Problem is that you have 69, you have scheduled doctor's appointments that you've been waiting a long time for. And in New Mexico, you have to like kind of like a special grant to be able to get it done. And when and we had to reschedule, how long would you have to schedule that out, or would you use it? About at a time, anybody have anything? I should know.
Give me just a minute. So juror 33, I wanted to talk to you a little bit. What kind of work is it that you do, sir? And you work 12-hour shifts? And how many days a week do you work?
3 days a week.
Okay. And then also, in addition to that, every other weekend? Or does that, or those 3 or 4 days include that weekend? Okay. All right. And juror 69, tell me a little bit about this, I guess, analysis that would occur. You're going to New Mexico April 17, and how long is it going to take for them to do what they're going to do? Okay. Let's talk about those dates for a minute, because the 16th is a Sunday. Ah, got it. Okay. And then, got it. Okay. I see. All right. So you would be going to New Mexico when? On the 15th or wait until the 18th? Okay. And do you already have that appointment set? Where is it in New Mexico? So 6 hours roughly? 6 hours roughly driving? Okay. Okay. All right. Here's what we're going to do. We're going to take about a 20-minute recess. So if I can have all of the jurors, number one, remember where your seat is. Number two, step out into the hallway and be ready to come back into the courtroom at 10 after 3. What will happen in the meantime is that the attorneys and I will be discussing jury selection, and it's actually, as Mr. Cellini indicated, it is a process of deselection. So there will be more jurors that I will excuse. And once that happens, I will have further instructions for the rest of you. So with that, I'll rise for the jury, please.
So there it is.
Well, I wondered if that's what happened when I put
No, thing blows on.
it was running, and then when you told me that I needed to move it, she showed up. So I wonder if what happened.
Oh, yes.
When that happened.
When that happened.
He's coming because I should be able to expel that person and I can't expel.
Okay, don't worry about it.
Stuck. So they're coming to take a look to see what I see.
Okay,
The worst we do is.
just shut it, yeah, right.
And
Start a new one.
And then everybody should still come back in.
Well, so long as she can't just start talking and broadcast and all that, it won't make any issue.
I've had to put makeup on my eyes to come out.
Black
eyes, yeah. Every time I'd ask, he punches me.
Thank you. You may all be seated. And Ms. Stauch, would you like to take your break now, or do you want to wait? You're okay for now? Okay, all right. Why not council take just a couple of minutes to talk amongst themselves? And in the meantime, I will work on my own list here.
Okay.
2, 3, 6, 7, 8, 9, 10, 11,
Yeah.
16.
She's heard so many people say that they don't believe in the insanity plea. She's like, oh shit. Also wondering what the phone icon thingy is for up there. That hasn't been there for the whole time. If anybody knows, tell me.
Five, 27, 33, 42, 6, 3, 66, 9.
Okay, I'm going to grant 66 off of the top. Looking at his work situation, I think that that is appropriate. In addition, I'm going to grant 33 for hardship reasons as well. And there was one other 20, 25. I'm going to grant, that's right on the cusp. Her trip to Hawaii is right on the cusp of maybe ending, and that's probably just a bad idea. So I'm going to grant 25 as well. Let's see, who else did you have here? 42. Oh, and 42 for the same reason.
All right. What happened? Go on break. I had to go to the other room. Didn't hear what they said. They usually keep their mics on, so we'll see if they come back in a couple of minutes. I might come back on later on tonight to talk about it. Not really much to talk about. I mean, like I said, it's interesting how many people don't believe in the insanity plea. She's got to be like, oh my God. But what else? What else is she going to do besides admit it? And or admit why she did it. Let's see if they're back. If they're not back, I'm going to go ahead and call it quits for the day and see you tomorrow. But let's And by the way, thanks for joining and watching.
To the court.
Good luck, you guys. Thank you. Sorry.
It's all good. Take your time.
Very much.
All right. First of all, I want to thank the remaining jurors that are here. I want to thank you for your time, your attention, and your honesty, and your dedication. Here's what we're going to do. The first thing that we're going to do is my staff is going to give you some contact or something to write down, some contact information. We need a phone number, an email. We're also going to be handing out cards to you that have your return time. You should anticipate to return on April 3 at 9 a.m. It's on the backside that they have the contact information, right? My card. Yeah, okay. So on the card, there'll also be, oh, it's on the front. And on the front of the card is contact information for me. Take that card, put it in your wallet, pull it someplace safe that you'll have it for the next 2 weeks. And what will happen is if something occurs, something changes in your life, some emergency or something like that, call us and let us know so that we can keep apprised of what kind of numbers we have for our jurors as of April 3. So we'll take a minute to have them hand that out to you, and then I have some other instructions for you. And juror 26, how's your allergies doing? You seem to be doing better. You doing okay?
Sitting outside of my own job.
Okay. Absolutely.
Scan document to the summons.
While they're passing this out, that's one of the things that I can talk about. For anybody who needs anything for your employer to show that you are actually here, you were here today, and you will be with us for 6 weeks or so, starting April 3, let me know. I can get you a letter. It's from me. It's got our letterhead on it. It explains that you're a juror on this case, what your dates of service are going to be, and that you're not actually on a beach in Cabo somewhere having a great time. So if anybody needs that, or if you need it even before we start on April 3, contact me based on that information. You can send, Jack, does that have your email on it? Okay. You can just call us, leave a message, and we can get a letter to you. So for anybody who needs something like that, let us know. We'll take care of you. Yes.
Sorry, I work from home, so everything I do is just uploaded.
Yeah, no, that's fine. What would happen is we would send it in a PDF format, and I will write the letter out. We'll scan it so that we know that it's in a PDF and can't be changed, and then we'll send it to you. So if you need it, just let us know. Okay. Do you need one before you leave today? Hang around for a little bit. I'll get you one today. I can put it in your hand before you go today. Okay, hold on, because I need to write down the names, because it's bad if I say to whom it concerns and you fill in the blank with the name. That's a bad thing. So, so juror 26, 28. Saw another hand. And you are 52 and 22 and 48. Okay, I can get that done. The downside to it is you're gonna have to wait towards the end of the day, so you do have to sort of stick around. But I can get you a piece of paper in your hand. You want an email? You just need to well, you're gonna be giving us your email, so just we'll send it to you. Yeah. Yeah. You guys all wanted email? I got it. I got you covered. Yeah, well,
My work schedule is like 3 months out, so.
no, it's okay. It's not a problem. It's, I had forgotten that we were getting all email addresses from all of you folks, so it actually makes it easier for us, so it'll be fine. For those who are wanting the letters, if anything happens and you don't get it, by tomorrow or the next day, call and let us know, because there's a problem. Okay.